what happened, and the core of that is the basic principle is that the appellate courts, the upper level courts, are supposed to be reviewing what the lower courts below them did, sort of checking the work, looking at the decision, seeing if it's right or wrong. You're not supposed to have the court at the top be the first one to take a look at the merits of the case. So that's why what happened here was really unusual. We had a hearing in the trial court where there were certain procedural objections raised to the lawsuit, raised by the Attorney General and the Secretary of State. And the trial court judge denied those procedural issues, denied those procedural objections. And then, instead of going to the Court of Appeal, the Attorney General and the Secretary of State skipped the Court of Appeal, went straight to the state Supreme Court, asked the Supreme Court to take up the case, even though the Court of Appeal hadn't ruled on it. And the state Supreme Court said, yeah, we're going to take up the case, but we're not going to disagree with what the trial court said about the procedural issues. We're just going to skip all those procedural questions, skip right to the end of this case, and address the merits.
Thank you, ladies and gentlemen, for joining us once again on The State of Freedom.
The State of Freedom is a listener-supported podcast. We're committed to pursuing the truth about policymaking, decisions, and situations in Louisiana and at the national level that stand to impact our freedoms.
Please become a monthly supporter of The State of Freedom at freedomstate.us as we continue to expand the voice of liberty across Louisiana and beyond.
All right. Well, joining us today is returning guest William Most. He's the New Orleans attorney who brought the case against our Secretary of State, Nancy Landry, on the proposed constitutional amendment 2. We have invited him on the show, back on the show today, to share an update on the case. Before we get to that, let me read the scripture of the day. It is short and sweet. It's John chapter 14, verse 31. And it says, I am doing exactly what the Father destined for me to accomplish so that the world will discover how much I love my Father. Now come with me. And these are the words of Jesus when he was explaining to his disciples that he had to go to the cross. And earlier in this passage in chapter 14, he's explaining that it's their love for Jesus that will empower them. His disciples' love for Jesus is what will empower them to obey his commands. And what I never noticed before are the words at the end of that verse, now come with me. And I think it's so profound. He was inviting, or maybe depending on the tone of the voice you hear when you're reading it, maybe he's commanding each of his disciples to join him in pursuing the destiny that the Father has for them with Jesus, so the world will discover how much they love God. And what struck me was that the invitation or command to come with him is for us today as well. So my question for you all to ponder today is this: will you follow Jesus to your destiny, no matter what the cost, so the world will know how much you love God?
And will we follow truth to the cost, to the end, no matter what it costs us? Yeah, that's a great, tremendous admonition. If we're committed to the truth, then we're going to pursue the truth at whatever cost because we've made the commitment. And that's where we are. And our commitment is to Jesus Christ. You know, in the grand scheme of things, lesser commitment, but a very important commitment temporally is the commitment that William Most has made to make sure that voters are fully aware of what they are voting on March 29th with respect to Constitutional Amendment 2. William laid out in the lawsuit filed by two teachers and a pastor very clearly exactly what the deficiencies are in Constitutional Amendment 2, took it before the trial court. The trial court refused to throw the case out and said there has to be a hearing on the injunction on the merits. The Attorney General appeals it up to the Louisiana Supreme Court, and the Louisiana Supreme Court dismisses the suit over some very, very powerful dissents. And here to talk about it is William Most, the attorney for the plaintiffs. William, thank you for joining us for a few minutes today, sir.
Well, thank you. And you all have been following this issue and this case from the beginning. And so I really appreciate all the time and attention you've put to it.
Thank you, sir. William, tell us about the Louisiana Supreme Court. I know that there were some strange developments. The majority ruled that the ballot language is sufficient, despite not really hearing any evidence on it, and despite the fact that that wasn't really the objection that the Attorney General was raising. Tell us about the Supreme Court ruling.
Sure, absolutely. And just to get the viewers back up to speed, because some of them have been with you probably every episode, some may not have. So this grows out of repeated attempts by some state officials to rewrite our state's constitution. And one of those attempts last year was halted by Republican legislators who stopped a constitutional convention from rapidly rewriting the Constitution. But then some state officials kept pushing. And so on the ballot on March 29th will be a series of 4 proposed amendments, 4 proposed ways of changing our Constitution. Number 2 of that 4 amendment list is Amendment 2, which would, if passed, make changes to the state constitution that span more than 100 pages. So rewriting broad swaths of our state's core foundational document. And those changes spanning 100 pages would include things like narrowing constitutional protections for churches and religious ministries, narrowing local control over taxes, liquidating certain education funds that pay for early childhood education, removing constitutional funds that prevent infant mortality care, and then deleting authorization for farmers and fishermen's programs. So there's a lot of different things in Amendment 2, some of which people might like, some of which people might not like. But the core is voters need to know about what they're being asked to vote on before they vote on it, right? And so my clients, who are 2 teachers and a pastor, brought a lawsuit that said, it's okay to change the Constitution if you follow the rules and are truthful with voters. And that's not happening here.
Yeah. William, you're exactly correct. The core of all of this, and this has been really the centrality of our objection to this amendment, is that regardless of how you choose to vote, people have a right to vote in any manner that they choose, but everybody has a right to know specifically, fully, and completely what they are voting on. Talk about Justice Chief Justice Weimer dissented, Justice Piper dissented, and Justice Guidry wrote very powerfully in dissent about this decision, really articulating your argument about all of this. Tell us about the dissent.
Yeah. So what has happened over the last week is pretty extraordinary. So the way a normal lawsuit works almost all the time is you have a trial court judge who looks at the case and rules on it. Then it goes up to a court of appeal. And then sometimes it goes on to the state Supreme Court. What happened, and the core of that is the basic principle is that the appellate courts, the upper level courts, are supposed to be reviewing what the lower courts below them did, sort of checking the work, looking at the decision, seeing if it's right or wrong. You're not supposed to have the court at the top be the first one to take a look at the merits of a case. So that's why what happened here was really unusual. We had a hearing in the trial court where there were certain procedural objections raised to the lawsuit raised by the Attorney General and the Secretary of State. And the trial court judge denied those procedural issues, denied those procedural objections. And then instead of going to the Court of Appeal, the Attorney General and the Secretary of State skipped the Court of Appeal, went straight to the state Supreme Court, asked the Supreme Court to take up the case, even though the Court of Appeal hadn't ruled on it. And the state Supreme Court said, yeah, we're going to take up the case, but we're not going to disagree with what the trial court said about the procedural issues. We're just going to skip all those procedural questions, skip right to the end of this case, and address the merits. And we decide, the Supreme Court, 4-3 decision said, plaintiff's claims are wrong, case dismissed. And that's very strange. I've never seen that happen before, because no lower court at any point in this process ever got to the merits or heard any evidence on the merits. The first court to say anything about the merits of this case was the state Supreme Court. And that's putting things completely on their head. And look, you don't have to take my word for it, right? Take it from the dissenting justices. As you pointed out, 3 judges dissented. One of them, the Chief Justice, wrote that, quote, when this court rules without a hearing or trial at the district court level, without prior review by the Court of Appeal, and without oral arguments at this court, the public is largely left out of the process and remains in the dark. He went on to say, such a process erodes respect for the fairness and impartiality of the system of justice. And then he crucially said, because of this, any evidence the parties intended to introduce will now be essentially swept under the rug because they never got their day in court. So that was one justice, joined by Justice Griffin. Another justice wrote, I think this is the one you were mentioning, Chris, I strongly disagree with the majority that the proposed ballot language is sufficient and transparent to accurately summarize and put voters on notice concerning what they are being asked to vote for or against.
We've all had instances crop up where we could use the advice or skills of a trusted attorney. Whether you're looking at the implications of new laws for your business, signing a contract or a lease, looking to write a will or establish a trust, or even resolve a dispute with your credit card company, Legal Shield has got you covered. For over 50 years, Legal Shield has made it affordable and easy to access a dedicated lawyer. With the app, Legal Shield is like having a lawyer in your back pocket. For covered emergencies, Legal Shield is here for you 24/7, plans to fit any stage of life. The State of Freedom is proud to be teamed up with Legal Shield as clients and affiliates. To learn more or to sign up, visit the Shop Our Partners page on freedomstate.us or check out the link in the show notes. Thank you for supporting the State of Freedom.
Yeah. And William, did you get your proverbial day in court? I mean, did you walk in there and have to argue anything?
Not at the Supreme Court. We got a phone call at 9:06 a.m. on a Friday saying, the justices would like your briefing by 5 p.m. today. The court gave no indication to any party that it intended to skip the procedural questions and go right to the merits. So, I personally have concerns about this process, and I think those are really echoed by the Chief Justice, or I'm echoing him when he said this erodes respect for the fairness and impartiality of the system of justice. So this is strange. My clients are weighing their options going forward, but, I think people should know the truth about Amendment 2, which is that it isn't transparent with voters. And regardless of what these 4 justices think, people should learn on their own about what Amendment 2 would do to their Constitution.
Yeah. And what are their options, William? I mean, is there any further recourse, or is this like you've reached the end of the road?
I think that's to be determined. There's sometimes parties can ask a court to rehear an issue, but, my clients are trying to figure out what's going to happen next. I think really, at its core, it may be that this ultimately rests with the voters of Louisiana. They will be the final word on whether Amendment 2 is telling the truth or not. They'll be the final word about whether the ballot language is misleading or not. So every person in Louisiana who's thinking about voting, they want to learn more so that they can cast their ballot in the way they wish.
Yeah. And maybe, Chris, if before you go, I might just try and put a little clarity on this for the non-lawyers out there who are like myself. You and I kind of parsed through this earlier today, Chris, and what we came to was at the end of an amendment, a proposed amendment being passed by the legislature, the process is the committee, I believe this is the process, people can write in and correct us if we've got it wrong, but the committee puts forward what the ballot amendment language would be. And so at the end of the day, the legislature is the party that's wronged the people in terms of putting this forward in the way that it is. It's the Secretary of State that holds the pen, so to speak, on just getting it on the ballot, making sure that what the legislature does is executed and made available to the people. So what I understood is that your suit, William, was an injunction to stop the process, just hit pause, and I think you've called it a pause on a previous episode, so that people would not be voting on something that they didn't have full clarity on. And so this this is not necessarily an indictment, so to speak, on the Secretary of State herself or the office. It's just saying, hey, guys, slow down. Can we just get this right? And they have leapfrogged over every institution to tell us that we are going to take this on the ballot, whether you like it or not, without a hearing, basically. And I just find that so morally offensive. And I find it shows great disdain for the voters.
Yeah, I think that's right. And the Secretary of State's lawyer said in court, look, this wasn't the Secretary of State's fault. She didn't write this. And we responded that this lawsuit isn't about blame, right? It's not about pointing the finger at who did right or who did wrong. What it's about is making sure we do things right in the future, making sure that, if something is going to go before the voters, it has to comply with the basic rules of the road that are there for transparency and fairness, right? Things like the ballot language has to be not misleading. Or, if you're going to revise less than one full article of the Constitution, you have to do it one thing at a time. That's the one object rule we talked about last time. And so we weren't seeking to blame anybody or point the finger, but just to say, let's make sure this is right and transparent and fair before we take, an axe and start chopping out big parts of our state constitution.
Yeah. And you imagine the precedent. Again, regardless of how people choose to vote, imagine the precedent. If this stands, if the voters at this point do not vote this down, the precedent that is set is that the government can issue an official ballot on critical constitutional amendments or on other critical propositions that is not accurate, that is incomplete, that completely omits certain provisions of the bill, in this case, a 115-page bill, and they can do it with legal impunity. That is a dagger in the heart of a democratic republic. There's no question about that. If we cannot rely on the official government-issued ballot language in terms of what we are voting on and the veracity of what we are voting on, as far as I'm concerned, we don't live in a constitutional republic. We don't live in a democracy. And that's why this is so very important. Your suit was so very important. And now at this point, it is very, very important that if for no other reason, voters vote this down specifically because the government has not been transparent with the citizens of Louisiana. What say you?
Yeah, look, that's something I've been thinking about a lot over the last 48 hours, right? Because I really worry that if this passes, it will encourage state officials to repeat this play, right? Because this language, I think, appears to me to be deliberately misleading and tricky, right? I'll give you a concrete example. It says that Amendment 2 would modify certain constitutional funds, right? But what it actually does is delete those funds, destroy them. So that's not the way normal people use the word modify. If you take your car to the shop and the technician, the mechanic says they're going to modify your car, you come back, it's completely destroyed, you'd feel substantially misled, right? And I worry that if this sort of tricks in language, trick the voters kind of play works, when something works, people do it again, right? And I really have concerns that this play will be repeated and you'll see ballot language getting more and more misleading, tricky, dishonest in the future, and in a way that is dishonest about changes it's making to our foundational document. And look, that keeps me up at night.
Yeah. And William, the fallback position, of course, by the people who are proponents of this is that it doesn't really matter. Let's just take, for example, the religious and narrowing of the religious tax exemption and the complete evisceration of the secular nonprofit tax exemption. They say, oh, it really doesn't matter because it will remain in statute, or we will make sure that we pass legislation that protects it. First of all, we don't know 100% what a future legislature or even this legislature may do. But secondly, it doesn't matter. The fact of the matter is you are removing constitutional protections from the Constitution that you're asking people to vote on, and you're either misleading people on that, or in the case of the secular nonprofits, you're omitting it entirely. And you can't do that in a free society and expect people to remain free and expect people to be able to make an informed vote. And so that is the core of it. And,
to be able to expect people to trust your public officials, right? Why this is not only eroding trust in that what they say is what you're voting on, but it's what they say means anything at all.
Yeah, I mean, look, Ronald Reagan said trust but verify, right? And the point was trust is great, between friends and family, but you want to avoid situations where you have to trust someone with important things without being able to make sure that it's protected, right? And so, look, if you told me, don't worry, I'm taking freedom of speech and freedom of worship out of the Constitution, but I'll put it into a statute, I would not feel comfortable with that, right? There's a reason why we have important things are put into our constitutions. And so putting them in a statute is better than completely eliminating them. But as you pointed out, Chris, it leaves it up to the whims of a future legislature that might or might not agree that those are important things. So yeah, I worry when things are taken out of the Constitution.
So let me ask you this, William. They say that, don't worry, this will be protected in statute. If that's the case, can you think of any reason why they would be removing these protections from the Constitution to begin with? Is there another reason? Do they have to do this in order to enact broader tax reforms? Or do they have to do this for some other reason? What's the reason why, if they intend to permanently protect these organizations, why would they be removing or amending these things in the Constitution?
Yeah, well, look, I think that's a really good question, right? If they're telling you this doesn't matter because it's we're putting it into a statute, then why are you trying to do it in the first place, right? If you catch someone taking something out of your house and they say, don't worry, I'm putting it in your car, it's fine, you would still be asking, why are you taking that thing out of my house? Why do you have it in your hands at all, right? You would have a bunch more questions and you would not feel great that some stranger was taking something out of your house and put it in your car. So yeah, no, I think that's exactly right. Why are they doing it? What's the benefit? Who stands to benefit? These are the questions you should be asking if someone's robbing your Constitution.
The secret to losing weight 2 times faster has gone viral. See the transformations hundreds of thousands of people are experiencing around the world with the Slender Eyes drops. These homeopathic drops are proven to control appetite, support thyroid function, help balance the body's pH, improve energy, boost mood, and increase metabolic rate. I've heard firsthand testimonials from droppers in their 20s to droppers in their 80s who say that the Slender Eyes drops have completely revolutionized their lives. Try the drops today to see the results for yourself. To learn more about the Slender Eyes drops or other incredible natural wellness and lifestyle products, email me at info@freedomstate.us and put drops in the subject line or visit the Shop Our Partners page at freedomstate.us. We also have links to those in the show notes. Thank you for supporting the state of freedom.
Yeah, and even if this was well-intentioned, I think it's a very ham-fisted approach, and I would like to see something very methodical, very much explained to the people, step by step. This is why, this is the thing that needs to come out of the Constitution. This is our rationale for why, and this is what it's going to mean for you, the people of the state, going forward if we make this change. That's the kind of respect the people deserve, because the people voted for the Constitution we have. And am I a huge lover of the Constitution that we have? I think there could be considerable changes to it. I have no problem with making changes to it. We can't do it all in one time. This is, look, at the end of the day, this, the ruling, William, really made me angry. Really, I was really unimpressed by the way that the Supreme Court handled that. I was very happy to see the dissent. And my point of view is, even if you agree with every single thing in Amendment 2, the way it's written, still vote no on the principle that it is done and has been presented in such a way that is insulting to the people. It's insulting to our right to know what's in it.
I think that's a great point, which is we need to send, as an electorate, as a people of Louisiana, we need to send a message to state officials that you can't do this, right? You can't try and trick us with rewriting the state constitution. And I think they need to get that message loud and clear. And so I won't tell anyone how to vote. Look, I'll say I'm voting no on Amendment 2 and all 4 amendments. But I think it is really important that people learn about the truth about Amendment 2, learn about how it would affect their churches, their fraternal organizations, their schools, their children, and make an informed decision. And keep in mind, like you said, Danielle, maybe we need to send a message. You can't try and pull a fast one on us like this. That's not okay.
That's not okay. And if the most powerful thing that comes out of this suit, William, are these dissents, these eloquent dissents, that is in and of itself is a powerful contribution to the rule of law and to the continued effort to ensure that citizens fully participate in the democratic process. So that is a powerful contribution that you've made through this lawsuit. And, remember that today's dissents are very often tomorrow's rule. Let's remember that. And thank you, William Most, for your courage in bringing this suit. And if we are fortunate enough to defeat this amendment, there's a lot of credit to be laid at your feet. So God bless you, sir.
Well, and thank you. You guys have been the most consistent voice and following this every step of the way, I think, of any outlet I've seen. So thank you very much, both Chris, Danielle, for your attention to this.
Thank you, sir.
Absolutely. Thank you, William.
Thanks for joining us today on the State of Freedom. Be sure and check out the show notes for this episode. You can always go there and find the calls to action and resources mentioned in the show, and you can find out more information about our advertisers there as well. If you want to learn more about us or support our work, visit freedomstate.us. To get involved with Louisiana Citizen Advocacy Group, visit lacag.org. We'll see you next time. God bless.